Failure to comply with a dedicated encrypted criminal communication device access order, or DCCD access order, is an offense under Section 80O of the Law Enforcement Powers and Responsibilities Act 2002, which carries a maximum penalty of 5 years in prison. To establish the offense, the prosecution must prove beyond reasonable doubt that 1. You were a relevant person for the purposes of a DCCD access order, and 2. You failed to comply with a lawful direction given under the order by an executing officer, or you gave an executing officer information that was false or misleading in a material particular, in purported compliance with the order without informing the officer that the information was false or misleading. And a relevant person is a person to whom a DCCD access order applies. A DCCD is defined by Section 192O of the Crimes Act 1900 as a mobile electronic device that 1. Is specifically designed or equipped to facilitate communication between persons who are reasonably suspected of being involved in serious criminal activity to defeat law enforcement detection. 2. Uses hardware modifications or software deployed on the device that a. Temporarily or permanently modifies the device's factory operating system to block or replace key features usually available on the device's operating system, and 3. Enables encryption of communication between users, and 4. Is configured in a way that specifically impedes law enforcement access to information on the device. Examples of key features usually available on a device may include voice call, web browser, and geolocation services. Examples of configurations intended to impede law enforcement may include installing a duress pin or password that wipes data on a device, using a mobile service that is unable to trace to a particular individual, and ensuring a mobile phone does not have an International Mobile Station Equipment Identification Number, or IMSAIN. Serious criminal activity is defined as an offense punishable by at least 5 years in prison or obtaining material benefits from such conduct, or an offense designated by the Criminal Assets Recovery Act 1990 as a serious criminal offense. Applications for DCCD access orders are made under Part 5A, Division 2 of the LEPRA. A reasonable excuse for not complying with a DCCD access order does not include the fact that complying would tend to incriminate you or otherwise expose you to a penalty. You are not guilty of the offense of failing to comply with a DCCD if you establish, on the balance of probabilities, that you had a reasonable excuse for your conduct. General legal defenses to the offense include duress, necessity, and self-defense. If you are able to raise evidence of a general legal defense, the onus then shifts to the prosecution to prove beyond a reasonable doubt that the defense does not apply to the circumstances of the case. You are entitled to an acquittal if the prosecution is unable to do this.
Going to court? Call Sydney Criminal Lawyers on 9261 8881 to arrange a free first conference. Watch our latest video here.